In common law, assault is harmful or offensive contact with a person. An assault is carried out by a threat of bodily harm coupled with an apparent, present ability to cause the harm. It is both a crime and a tort and, therefore, may result in either criminal or civil liability. Generally, the common law definition is the same in criminal and tort law. There is, however, an additional criminal law category of assault consisting of an attempted but unsuccessful battery. The term is often confused with battery, which involves physical contact. The specific meaning of assault varies between countries, but can refer to an act that causes another to apprehend immediate and personal violence, or in the more limited sense of a threat of violence caused by an immediate show of force. Assault in many U.S. jurisdictions and Scotland is defined more broadly still as any intentional physical contact with another person without their consent, but in England and Wales and in most other common law jurisdictions in the world, this is defined instead as battery. Some jurisdictions have incorporated the definition of civil assault into the definition of the crime, making it a criminal assault intentionally to cause another person to apprehend a harmful or offensive contact. Related definitions. Battery in common law. Criminal assault often accompanies battery. See common assault. The elements of battery are a volitional act done for the purpose of causing a harmful or offensive contact with another person or under circumstances that make such contact substantially certain to occur and which causes such contact. Thus, throwing a rock at someone for the purpose of hitting him is a battery if the rock in fact strikes the person, and is an assault if the rock misses. Aggravated assault. Aggravated assault is, in some jurisdictions, a stronger form of assault, usually using a deadly weapon. A person has committed an aggravated assault when that person attempts to cause serious bodily injury to another person with a deadly weapon, cause grievous bodily harm to another person, such as rape or kidnapping, have sexual relations with a person who is under the age of consent. Aggravated assault can also be charged in cases of attempted harm against police officers or other public servants. Defenses. Although the range and precise application of defenses varies between jurisdictions, the following represents a list of the defenses that may apply to all levels of assault. Consent exceptions exist to cover unsolicited physical contact which amount to normal social behavior known as de minimis harm. Assault can also be considered in cases involving the spitting on, or unwanted exposure of bodily fluids to others. Consent may be a complete or partial defense to assault. In some jurisdictions, most notably England, it is not a defense where the degree of injury is severe, as long as there is no legally recognized good reason for the assault. This can have important consequences when dealing with issues such as consensual sadomasochistic sexual activity, the most notable case being the Operation Spanner case. Legally recognized good reasons for consent include surgery, activities within the rules of a game, bodily adornment, or horseplay. However, any activity outside the rules of the game is not legally recognized as a defense of consent. In Scottish law, consent is not a defense for assault. Arrest and other official acts. Police officers and court officials have a general power to use force for the purpose of performing an arrest or generally carrying out their official duties. Thus, a court officer taking possession of goods under a court order may use force if reasonably necessary. Punishment. In some jurisdictions such as Singapore, judicial corporal punishment is a part of the legal system. The officers who administer the punishment have immunity from prosecution for assault. In the United States, the United Kingdom, Australia and Canada, corporal punishment administered to children by their parent or legal guardian is not legally considered to be assault unless it is deemed to be excessive or unreasonable. What constitutes reasonable varies in both statutory law and case law. Unreasonable physical punishment may be charged as assault or under a separate statute for child abuse. Many countries, including some U.S. states, also permit the use of less severe corporal punishment for children in school. In English law, S. 58 Children Act 2004 limits the availability of the lawful correction defense to common assault under S. 39 Criminal Justice Act 1988. Prevention of crime. This may or may not involve self-defense in that using a reasonable degree of force to prevent another from committing a crime could involve preventing an assault, but it could be preventing a crime not involving the use of personal violence. Defense of property. Some jurisdictions allow force to be used in defense of property, to prevent damage either in its own right, or under one or both of the preceding classes of defense, in that a threat or attempt to damage property might be considered a crime subject to the need to deter vigilantes and excessive self-help. Furthermore, some jurisdictions, such as Ohio, allow residents in their homes to use force when ejecting an intruder. The resident merely needs to assert to the court that he felt threatened by the intruder's presence. This defense is not universal. In New Zealand, homeowners have been convicted of assault for attacking burglars.